right, good afternoon, everyone. We're ready to get started today. The House Subcommittee on Human Resources is going to be hearing Senate Bill 62 today. Senator Ralph Hudgens, are you here? Oh, there you are. Why don't you go ahead and start it off? And you can stand or you can sit. It's up to you. All right, let me figure out where I'm going. Try that.
That way I can run quickly if I see anybody launching an attack against me. Thank you, Mr. Chairman. I bring to you Senate Bill 62, which we have, and I do not have a copy of the legislation with me, but this is the prompt pay. This is the prompt pay statute in Georgia now. Well, it's not it's an addition to existing law, the existing prompt pay statute. And what this is doing, under current Georgia code, there's a 15-day time frame that you need to pay your bills. And what we have found, and this legislation was brought to me by the Medical Association of Georgia, we have found that insurance companies were not timely paying the claims that were sent to them by the medical providers. And so in consultation with the Department of Insurance, this Senate Bill 62 was crafted, and what it's doing is we can regulate health care plans in the state of Georgia that are providing individual coverage, or if they're providing small business coverage, small business group plans. But we acknowledge the fact that ERISA programs, which I know that this is not an insurance committee, but Representative Hurd knows exactly what I'm talking about. ERISA programs are the large self-funded plans. They're self-insured. Your Home Depots, your UPSs, your large companies, Coca-Cola, they all have ERISA health care programs, and they are exempt from state regulation. What Senate Bill 62 does is, in the state of Georgia, the Department of Insurance licenses and regulates third-party administrators. These are companies or individuals that administer the programs for insurance companies. And so what this bill does is it says that if you're a third-party administrator, even if you're administering an ERISA program, an ERISA plan, you have to comply with the prompt pay statutes in the state of Georgia. And there's been a lot of argument, and I think you'll probably hear today that this bill is unconstitutional, that it was ruled so by a district court, 8th District Court on a Missouri prompt pay statute. But I had Legislative Counsel Sewell Brumby draw me a bill in response, because my question to him was, can Senate Bill 62 do what it's intended to do, which is regulate third-party administrators? Sewell wrote me a response back, and I believe you all have a copy of it, saying that yes, we can do what Senate Bill 62 says it's going to do, that we can regulate those third-party administrators which the state licenses. And I was handed yesterday a ruling from this 8th District Court saying that the Missouri plan was ruled unconstitutional. So I went back to Sewell and I asked Sewell, and I gave him that flyer, I guess you'd say, a kind of a press release on this, and I said, Sewell, does this have any effect on the letter you previously wrote me? And the letter was written on February 4th. Will this change your opinion on that letter that you wrote me saying that Senate Bill 62 can indeed regulate third-party administrators of ERISA plans. And so he said, I'm going to read this, but I'm not going to look at this press release. I'm going to go back and look at the decision, look at the determinations in the case, which he did, and said, I will get back to you and tell you. Well, he called me yesterday afternoon, and he said, upon further investigation, I stand by my letter. Senate Bill 62 can regulate third-party administrators in Georgia. And so with that, I would like to turn it over to Donald Palomacino, who is attorney for the Medical Association of Georgia. He's the one, in conjunction with the Department of Insurance, that asked me to sponsor this legislation. And rather than get into a legal fight, which I'm not an attorney, I would like for Donald to answer any of these legal questions. So if it's permissible, Mr. Chairman, can I let Donald Palomacino speak? Okay. And then I'll come back and answer any questions. Well, I can take any questions now, but there may be some that I can't answer. All right. Why don't we hear from Donald?
Thank you, Chairman Hudgens. First of all, I want to thank all of you for giving us the opportunity to present this bill today to you. I also want to thank Chairman Butler for giving us the opportunity to have a hearing on this. What we passed out to you is Sewell Brumby's opinion, but also an expert opinion from Mark Rust, and he's from Barnes & Thornburg, and that is a law firm. And basically, Mark Rust's pedigree is that he is looked upon as one of the national experts in ERISA. He actually addressed and worked on cases that were at the U.S. Supreme Court, the Rush versus Moran case, the Miller versus Kentucky Association of Health Plan cases back in 2001 and 2002. So he knows this issue. He knows it in and out. We gave him the bill as it's in its current form. He looked at it. He doesn't find any preemption issues, just as Sewell didn't find any preemption issues. And I just want to point out, Sewell is your attorney. He is the attorney for the legislature here, and by far he's an independent opinion. I mean, I've said from day one that the plans can bring in 10 experts, and I can bring in 10 experts that are going to have differing opinions on this very issue. And obviously, you know, my experts would probably tend to agree with me, and just like the plans, they've presented their experts in other committee hearings, and obviously they tended to agree with them. So I think Sewell here is right on the mark in terms of finding that this issue is not preempted. He's a neutral party in this. If I could just clarify a few things. This bill simply regulates third-party administrators. There's been questions about, well, what happens if the plan's not funded, and why should the third-party administrator be penalized for this? There's specific provisions in that bill, and that bill basically says that, look, if you can present evidence to the Commissioner of Insurance that the plan is not being properly funded, there's not going to be a penalty for the third-party administrator in way of a fine or in the interest. So that's there to protect Georgia businesses here. So if for any business to try to argue that, wait, we're being affected by this bill, I think they would have to read the bill, and it would show that they're not being affected by it. But also, this bill really is about small businesses. Small businesses in the state of Georgia. There was an economic impact study done just last year. And this economic impact study that was just looked at private practice physicians. It doesn't include physicians that are employed by hospitals. It doesn't include the economic impact of hospitals. Doesn't include the economic impact of optometrists, chiropractors, dentists, all the people you're going to hear from today. But just with regard to private practice physicians, it showed that physician offices supported more than 180,000 jobs and $20 billion in total economic activity. By 2020, the economic activity of the private physician office will increase to nearly 270,000 jobs in the state of Georgia and $32 billion in total economic activity. Also, private practice physician offices support more than $1.2 billion in state government revenue and $1.5 billion in your local government revenues. So what does this mean? Well, if you look at it, that's about half the size of what the construction industry, when it was in its boom, I mean, obviously not including the current economic conditions, was doing. But also, that's what the financial and insurance industry did combined. So the bill is about small businesses and it's about small practices. So that's what the bill's intended to do. This bill is the result of a compromise that resulted from last year in 2008 with the House Insurance Committee. This bill was agreed to by the Blue Cross Blue Shield, the Georgia Third-Party Benefit Administrators, but also the Medical Association of Georgia. And this bill passed out of the House of Representatives last year 134-1. Because it was in a different form, we had to go back for an agree, and on day 40 we didn't have enough time to get the agree. But this bill has passed in 2007, the Senate 44-1. It passed the Senate this year 49-0. And we had a House companion bill 342, which was in the Insurance Committee. That passed the Insurance Committee this year. So in total, we've had 2 negative votes in the entire 3 years on this particular bill. Again, it is a compromise. The language that you see before you, it's the language that we ended with last year on Sine Die. It's the same bill. And that's what the bill does. And if I can answer any questions, I'd be more than happy to.
All right, we have a question from Representative Carter.
Thank you, Mr. Chairman. I just wanted to ask you, you said that if the physician or the provider does not get paid, that it would, and it was because the plan did not have the money, that the third-party administrator would not be fined?
Correct. Yes.
Is that the only instance where, in a normal situation when it doesn't take place as is described in this bill, who is going to pay the fine then? Who is going to be held accountable? Is it going to be the third-party administrator?
Correct.
So that'll be the only situation where they will not be held accountable.
Well, if they have the money and they're holding it, well, then they should be fined.
Exactly. I agree. But that's the only exception, is when the plan, the money's not there in the plan.
Yes, sir, that's right.
Okay. And who is going to administer? The insurance commissioner will
Yes, sir.
promulgate the rules of that?
That's correct.
Okay. Thank you.
And one other thing is that we have these RICO settlements that occurred as a result of a number of state medical societies back in 2000 that filed a lawsuit against a number of insurance companies, and the allegations were filed under RICO, the Racketeer Influenced Corrupt Organizations Act. And the idea behind it was that the plans had all gotten together in a scheme to defraud physicians and their payments. As a result, we have a number of settlements that came out of that. And some of the companies that settled in that case agreed for their fully insured business and their self-insured business to comply with the prompt pay statutes across the country. So the only problem is those settlements end this summer. So that's why the importance of this bill.
Next, we have Representative Bobby Reese.
Thank you, Mr. Chairman. And I apologize for being late, but I was talking to my insurance company. I had to buy my arm, so that's not a joke. Anyway, what I always do when I look at bills like this, and this is all complicated, and I'm learning a lot about insurance since I got hit 3 weeks ago the hard way, but why do we need this bill? That's a simple question. Why do we need this bill?
Because what we've seen is that third-party administrators are not timely paying their claims. What's happened is that we've had physicians testify and practice administrators in all of the previous committees, most recently in the Insurance Committee, where we had the room, this exact room, fully packed. And what they came down and testified to was that, look, we're receiving our bill payments 45 to 60 days out is the average. Okay, so what's happening is that there's a distinct difference between that and the fully insured plans, because the fully insured plans already have to comply with our prompt pay statute, and they are paying within the time frame.
Can I follow up, Mr. Chairman? Okay, thank you. But on page 4, line 131 through 135, it talks about an insurer is only subject to administrative penalty if they process less than 95%. Isn't it right now 100%? So we're
correct. Right.
Well,
right.
why are we dropping it down to 95%? It seems like to me you're giving the insurer more leeway. I'm looking at it from a constituent and the insured's point of view. Okay?
Correct.
So,
well,
so why are we doing that?
That's part of the compromise that we came to. Right. The plans, one of their concerns was that the Commissioner of Insurance has, at the present time, he can fine whenever he wants. And so they just wanted some certainty or some finality to that, some parameters.
Well, I guess my question is, how's that going to help my constituents in the 98th House seat? And who's going to determine the 95%? Are they going to go through and look at all the claims and do the math? And I mean, I don't know. It looks like it complicates things to me. But again, I'm not an insurance expert by any means.
Well, the Commissioner of Insurance Office felt that they were okay with that. They felt they've never expressed a concern to me or to anybody that I know of about that very issue. But again, that was part of the compromise that we work. Right now, there is no data which says what is the compliance rate of the third-party administrators, because they're not required to turn that information over to the Commissioner of Insurance unless asked. But they don't have to do an annual review such as the fully insured plans have to.
Next, we have Representative Ed Seltzer. Whoops.
Mr. Chairman, to the witness, appreciate your being here and laying out the details for us, or starting to. I do have some more questions for you, though. Make sure I understand the kind of comparison and contrast here. We've got self-insured companies, which you're referring to as third-party.
What you have is you'll have a company, and they'll hire a third-party administrator.
It's administrated through a third party, but the company itself is fundamentally self-insured, like a large corporation.
Correct.
Okay. That's really what's in play here. The other companies or other cases in which the insurance company pays, there are already provisions that in 30 days they pay for paper transactions, 15 days by electronic, correct?
Correct.
Are we looking to apply the same standard over to the third-party administrated claim?
Correct. Right now it's 15 working days across the board, just for fully insured companies. And what we're doing here as part of the compromise is giving them 30 days on paper claims to fully insured and to the third-party administrators, as well as the 15 working days on electronic claims.
Okay. How do you respond to the contention that that if Georgia does this and a number of states do the same thing, but it may be 45-30 in North Carolina, it may be 30 and 15 in Georgia, there's this sort of patchwork regulatory scheme, that's going to upset the current process, it's going to make things more complicated, it's going to over-regulate the industry. And that's certainly the contention that those who oppose the bill stand up. They say, wait a minute, there's a regulatory scheme over here for insurance companies, but this third-party administrator thing isn't subject to that. And by doing that, you're putting new regulation on that's going to mess up multi-state entities that can administer to multiple states by creating this patchwork that's hard to comply with. What's the appropriate response to that?
Well, these particular companies, they're self-funded. This law does not attach to the benefit plan in any way whatsoever, doesn't mandate benefits, doesn't require the benefit plan to do anything differently than they're already doing. This is just regulating the third-party administrators, and under current law, Georgia can already regulate third-party administrators. So,
I guess what I'm asking you to do is, what I need to get a feel for is, I want you to kind of attack the crux of the opposing argument to this bill, because someone's going to get up here in 10 minutes and say, well, you're going to throw off these national entities that do this. You're going to have a patchwork scheme across a number of states. And what I struggle with in these committees is if one person says their side, the other side kind of presents their perspective, but there's never sort of an engagement on the issues. It's hard to figure out who's kind of where we fall. How do you address the claim that this creates a confusing patchwork of payment standards? It might be 30 and 15 in Georgia. It could be 49 things in 49 other states. How do you address that claim head on? Because that's what we're going to hear in a second, and I want to be able to kind of process that from your perspective.
Well, I think what we need to look at is what's happening in Georgia. And let's address the problems that are in Georgia. I mean, what's going on in Wisconsin, with all due respect, is nothing that we have any control over in Wisconsin. But what we have to do is address the problems that are in Georgia. We talk about access to care issues and that people, there's not enough doctors in the state. Well, if you own a company, okay, say you own a garbage company, and you turn around and say, you know what, I want to expand to that county over there because they need garbage collection. But wait, I'm not getting paid on time. So wait, I'm not going to take the chance to move into another county. When people get paid on time, and according to the obligations that are there, when services are provided, then that fosters entrepreneurial spirit. Doctors can move into other areas and start addressing these issues.
I'm sensitive to that. I just want to, I really want to make sure that that you're able to address the issue that's on my mind, which is the core objection, which is that this creates a confusing patchwork. If you can address that, then and if the senator could.
Representative, one of the big fights that's going on right now, and I'm very active in the National Conference of Insurance Legislators, which are legislators, chairman of insurance committees from all over the United States. One of the big fights we're having is against this mindset that is in Washington that we need to establish an optional federal charter. What they're looking to do is take state-based regulation, which we have now, and make a, quote, Department of Insurance and have an insurance czar. And this is part of the debate in that whole thing. But I feel that we need to keep state-based regulators. We need to have insurance commissioners in each state that regulate what happens within that state. And this is I think a red herring that's thrown up, because all this bill does is regulate those third-party administrators that are licensed by the Department of Insurance over here in the Twin Towers. And so if there's a claim coming out of Wisconsin, as the attorney said, this is going to have no effect on them because we don't have any type of regulation on third-party administrators that are based outside of Georgia. These are Georgia-based and licensed third-party administrators that will have to comply with this Senate Bill 62.
Now, if there's a third-party administrator who's, say, incorporated in Ohio or North Carolina, but was operating in Georgia, would they not have to comply with this?
I think they have to get a license in Georgia. I'm getting information. Ron Jackson generally, when I'm doing, he's lurking around somewhere, but he's not here today from the Department of Insurance. But I think if they are doing a significant amount of business in the state of Georgia, then they are going to have to be licensed, and then they will be subject to the Senate Bill 62.
Okay. And I wanted to invite you to address the crux issue that I think is going to be on the table.
Okay.
Because I think that's going to be the issue we're going to hear in a second from the other side, and I just want to make sure you and Mr. Palmazzani could address that.
Okay. Is there any other questions?
Do have one quickie, but one more quick one. The compromise. Who was part of the compromise last year? You talked about Blue Cross Blue Shield of Georgia. I guess they're going to kind of do the north-south. Were there third-party administrators?
They were at the table. The alliance of what do they call Association of Health Plans in Georgia. The TPAs were there. Everybody was there. Now, one of the things that I didn't say, and Mr. Palmazzani mentioned it, was current law says that you have to comply within 15 days. A lot of the insurance companies says, well, these doctors refuse to give us electronic information. They insist on filling out paperwork and mailing it to us, and that's going to give us a problem. Well, currently they're under law under 15 days, but Senate Bill 62 says, okay, medical profession, if you send your claim in on paper, they've got 30 days to do it. They don't have to comply with 15 days. They have 30 days to comply with this law. But if it's electronically submitted, then there's 15 days. And this is an attempt. It's a carrot, not a stick, but it's a carrot to incentivize the medical providers in the state of Georgia to get in the, what century is this, 21st? 21st century, and start submitting this information electronically. And so that's another change that this bill does. And that was a compromise to the insurance companies, which says, we get these claims, and if there's a question on the claim, if they get a claim in and there's been a wrong code entered or something, and they send it back to the provider and say, you need to correct this, this is the wrong thing, then the 15 days is out the window, and any disputed claim. And Representative Reese, the 95% was also a compromise, because the insurance companies say, well, we essentially always comply with this 15-day, but sometimes there's something that falls between the chair, and so we don't want to be held liable for that one that might slip between the chairs or drop off the radar screen. And so this was another compromise, saying if you comply 95% of the time, then you're in good shape.
Next is Representative Manning.
Mr. Chairman, why is this bill in appropriations subcommittee?
That's what I ask.
For the life of me, I don't know anything about insurance, but all I know is if we're so happy with all these compromises, why don't we just go home and forget it?
Well, we got to make it into law first. So I'd be willing to accept a do pass motion. And
no, I don't feel qualified to make the motion. But,
well, I agree, and I question why was it sent to appropriations last year. And I talked to the chairman of appropriations, and he said, well, that's where it was last year. And I said, I beg to differ with you. It went to insurance last year. It ought to be in insurance. But here's where it is, and this is where we have to deal with it.
Well, I think maybe some of the thinking was the fact that there could be a distinct possibility that this bill could have financial ramifications to the state. If you're not aware, we are self-insured ourselves. I mean, I don't know. Does everybody on the committee understand exactly what we're talking about here? What's going on? Not really. Okay. In the cases of self-insured, basically, okay, let's use the state as an example. We are a self-insured entity. When you go to the doctor, if you're on the state health insurance plan, whomever your insurance company you're using, whether it's United or whomever, they're not paying your claim, okay? This is not a policy deal. The state actually cuts a check and pays for your doctor visit, and it goes through the administrator. We actually hire these different insurance companies to administer our health insurance plan. That's what we're talking about. This is the situation we're talking about. We're not talking about a situation where somebody's paying into a full insurance policy, like you may go and get an individual policy on yourself, and you're paying into it, and then the insurance company is actually paying claims. We are actually the state or company ABC or whomever, Coca-Cola or Home Depot, whomever may be self-insured. They're actually and they're paying cash for these claims. That's who we're talking about. And the only thing the insurance companies do in this kind of case is they sign a contract with whomever it is, and they basically say, we will handle your administration of your insurance plan, and we will also let you use our networks, right, which you have already pre-negotiated, fees or whatever it is with the docs and pharmacies and all that. Right. Do you think that was fair to say, to summarize about about what this plan we're talking about?
Yeah, that's fine, yes.
Okay.
And if I can just add one other thing, is that with the state, if you're worried about a financial impact, the CMOs, which administer the Medicaid program, but also the state health benefit plan, which is administered by United Healthcare, in their contracts with the Department of Community Health, they already agree to comply with the prompt pay statute. So, there's not going to be an additional financial impact on the state. In fact, it'll probably be less if this bill passes out, because it reduces the interest that would be owed on late filings. But also, on the days itself, contractors in the state of Georgia, they have to be paid within 15 days. Subcontractors got to be paid within 10 days. So there's already precedent for this, and we already have a Georgia prompt pay statute, but this extends it to the third-party administrators.
I've got a couple of businesses, and I just wish they'd pay me within any time.
Well, I mean, that was going to be one of my kind of points. I mean, you did say earlier that a lot of your doctors were complaining about the fact they weren't getting paid except for only a 45 to 60 day period average. Now, correct me if I'm wrong, but according to ERISA, isn't there some stuff in ERISA that states about how long you can take to pay?
ERISA doesn't directly get into the
you sure
the
about
payment of the days. ERISA addresses more of the benefits. That's what ERISA basically focuses on. There is no prompt payment. I mean, you have within some of the federal programs like CMS or something like that with Medicare, there is a statutory time period there, but not within, not that I'm aware of within ERISA.
Okay. Well, I guess on a personal level, yes, let's just amend the bill and make everybody pay everybody in 15 to 30 days. I mean, I promise you the banks don't pay me 15 or 30 days. I do a lot of work for them. I get lucky if I get it in 60 days, maybe more.
Well, I tell you, my water bill, I live in the city of Atlanta, and I got 13 days to pay my water bill when I receive it. So I feel the same way. But we all pay it.
All right. You finished? Next is Representative Henson.
Thank you. I think you've answered one of my questions, and that is the state health benefit plan, Medicaid and Peach Care are all prompt pay and will remain so. But is that correct?
I know the CMOs. I haven't looked at the Peach Care contract, but I know Peach State, WellCare, and AmeriGroup agree to comply with the prompt pay statute.
Great. With regard to what we're saying about confusing patchwork scheme, isn't it true that when a company does business in a state that it's subject to the laws of the state, and therefore any insurance company or third-party payer who's doing business in the United States in multiple states is subject to different laws in every single one of those states already?
Correct.
So what's the difference? I mean, we're just changing one of our laws for them to be subject to, but they're already subject to multiple different ones. And this, of course, does not affect the amount of money. What you're talking about is the time frame.
Right.
I have a question, though. Right now, insurance companies that are not where we're not dealing with third-party payers, is that exception in there for electronic 15 days and paper 30 days, or?
Right
I
now,
mean,
as
right
of
now,
no,
if
it's
someone
15.
was to bill, wasn't dealing with Blue Cross Blue Shield Direct, the employee, the Blue Cross Blue Shield was the insurance company
Right.
for a company, and the employee went in. Do they currently have that 15 days if it's filed electronically and 30 days? Or is this something new that we're putting in place for third-party administrators?
This is something new for third-party
If you look
administrators.
on page 4, line 110 and 111, it's the current language says the insurer within 15 working days after such receipt mail to the injured or other persons claiming payment, and we're adding in there now the insurer shall within 15 working days for electronic claims, that's added, or 30 days for paper claims.
I
So
understand.
that's added.
I read that.
Yeah.
I still don't think you're addressing. We are setting up a different category for third-party administrators that insurance companies do not have to adhere to right now.
Yeah, this bill just regulates third party.
I know. So my
Well,
question,
I think I can answer your question. What this bill says is that third-party administrators and insurance companies are going to be treated alike, and that you're going to have 15 working days for electronic claims and 30 days for paper claims.
they're both going to be treated alike. So
That's
in this
correct.
case, you have addressed insurance companies too, plus
is correct.
third-party. Why are we changing the current law from the current 15 days that they have in which to pay? I mean, seriously, for any provider that's doing business with does more business with an insurance company than with third-party payers, could actually find their payments being slowed down if they do paper claims as opposed to in the past.
It's part of the compromise.
It's part of the
that got us
compromise.
here.
I think it's a move to try to get the healthcare providers in the state of Georgia
You know
to
something?
start giving electronic claims rather than paper claims.
I just want to speak up on behalf of the providers. We have a lot of providers that we desperately want to keep in the system
Absolutely.
that are willing to take Peach Care and Medicaid, which currently is paying way below the usual customary fees in the state of Georgia. And as a matter of fact, the CMOs are cutting them even further, and thank goodness that the state hasn't cut them even further. A lot of them are providers that are individual providers, have been in business for many, many years, have not gone electronic, have small offices. And we're lucky because, honestly, it's hard to find providers in rural areas, small areas, to provide services for citizens of Georgia. And yet we're now trying to push them into this, filing and working electronically, when for a lot of them that's going to become a hardship, especially when they have small offices.
It's optional.
I understand it's optional, but it's also regarding payment, and it's regarding, and we're talking about the Medicaid and Peach Care and state health benefit.
Well, no, because the state health benefit, I don't think, this would affect the contract that they've signed, which says they'll comply with the 15 days of the existing prompt pay statute.
Well, the question is, are they in compliance with the contract they signed, or are they going to be in compliance with the law we're going to pass?
I think if a contract is more restrictive than the law, then the contract's going to.
But we don't know. I mean, we really don't know. We'd
I'm
say
not an attorney.
we think.
The provisions in the contract itself just make reference to the state statute. And so what's going to happen is that whatever the state statute happens to be is what's going to be the new time frame.
For that small provider that hasn't gone electronic yet, that is still used to receiving his money within 15 days, I'm concerned about us moving that to 30 days. That's all.
Thank you.
Okay, there's no more current questions. I'm sure you guys are going to hang around a little bit longer. I'm sure we'll have some other stuff that may come up later. I don't think we did a sign-up sheet, so we're just going to do this random. Make sure you state your name and who you represent.
I'm Aubrey Valines on behalf of the Georgia Chiropractic Association, the Georgia Optometric Association, and the Georgia Association of Marriage and Family Therapists and Devereaux Mental Health in Cobb County. We support this legislation. What I'd like to do is try to simplify this and not make it more complex. Even though I'm a lawyer, I'm going to try to simplify it. This bill attempts to do two things, and that is pay the bill promptly or tell the provider why you can't pay it promptly. Nothing else. That's what the prompt pay statute is about. And we would ask that you reverse that question. We think the crux of the matter is, why can't you pay the bill promptly, or why can't you tell the provider why you can't pay it promptly? We can bring in all kinds of experts saying that it is not in violation of ERISA, and ERISA does not preempt this, just as they can. But your counsel, Sewell Brumby, says it's not a problem. And as far as the patchwork, I think in some respects you're right about that. That is a question. But we have 50 different laws or more regarding practice, chiropractic and optometry vary in all 50 states. None is the same. Insurance law generally varies in all 50 states. But fortunately, that is simplified greatly now by programming into a computer. All they need to do is program it in their computer, and Georgia's this way, and Wisconsin's this way, and North Carolina's that way. As far as Representative Henson regarding the 15 to 30 days, it is a compromise. And I can tell you among my providers, we'd rather have this compromise whereby these TPAs have to pay in a prompt fashion than the additional. We like that better. It is a good trade-off where we go from 15 to 30 regarding paper. So it is a compromise. But again, please don't lose sight. I know it looks complex, but it's really not. It's about two things. Pay the bill promptly or tell us why you can't. That's it. I'll be happy to answer any questions you may have. Thank you.
I don't see any questions.
Thank you, Mr. Chairman, members of the committee. My name is Graham Thompson. I represent a coalition of Aetna, Cigna, and United, who are both insurance companies and then also third-party administrators of the ERISA claims that this bill seeks to regulate. I appreciate Senator Hudgens bringing the bill as a good friend. Unfortunately, we differ on this issue. I think we've heard Our attorneys think this bill does one thing. The Medical Association's attorney says something else. Legislative Council says one thing. The Eighth Circuit Court of Appeals in Missouri says one thing. I think the only people that are going to get promptly paid after this bill passes is a bunch of attorneys. Moving to the issue, ERISA clearly lays out, this thing's been around since 1974. It clearly lays out a national uniform federal framework for the way that ERISA plans and the third-party administrator of those ERISA claims should pay the provider. 30 days. That's set by the U.S. Department of Labor, not 50 different departments of insurance around the state. One place. By the very nature of the self-funded plans, these are larger businesses. These are the Cokes. These are the Home Depots. This is UPS. Because they're larger, they're going to do business across state lines. So it makes sense to have a uniform federal policy of the way these claims are governed. Now, the bill that was passed in '99 by the Georgia legislature, that impacted the individual market and the small business market. By their size, you'd think they would only do business within the confines of the state of Georgia. There wasn't oversight there. That makes sense. Let's regulate that. Georgia's got the toughest law that there is on the fully insured side. 15 days for paper, 15 days for electronic. It's pretty strong, guaranteed payment on 15 days. Now you come back a decade later, 2009, you say, now the Medical Association is willing to will and deal on 100% compliant to 95% compliant, and on an 18% penalty for late payment to 12% penalty because they want to go out and get that ERISA book of business because you've got a copy of a lawsuit right in front of you, a legal finding right in front of you. Missouri passed a similar bill with prompt pay. That's exactly what the strategy here is to get that legal case. That's why the real debate here comes down to does ERISA preempt state law or does it not? It's a legal fight. We don't want to have that legal fight. We think it's working perfectly fine with a uniform federal policy under the U.S. Department of Labor. In fact, strong regulation currently resides at the U.S. Department of Labor. Like I said, 30 days. We have 30 days to make a determination on payment. If we don't, we get fined, the third-party administrator of those ERISA claims. And so Representative Reese asked a good question. He goes, why are we scaling it back from 100% compliant to 95% compliant? Well, I think this is an important case. Department of Insurance here in Georgia, since 1999, when the Georgia legislature passed a bill giving the Department of Insurance oversight over the individual market and over that small business market, the fully insured, they started keeping an annual report of the compliance of the insurance companies paying the doctors in a timely way. Over that 10-year period, compliance by the insurance companies has been 95 to 97% compliant. 95 to 97% compliant. So I think what we've heard from the Medical Association is one time somebody didn't get paid over here or a couple times somebody didn't get paid over here. The data is on our side. I charge the Medical Association with showing concrete data, facts and figures of us not paying on time. Similarly, I think the good question was asked, why are we setting up this whole new class of business? Why are we saying that the docs get paid in 15 days, yet the people that come and cut the grass out inside of the doctor's office, the Coke machine, FedEx that sends these paper claims to the insurance companies, there's nothing in here that says the docs have to pay them in 15 days. So, I don't think this legislation is necessary. I think we have proper state oversight now of the fully insured market that was passed in 1999. Since 1974, 35 years, we've had U.S. federal uniform policy oversight at the U.S. Department of Labor over the ERISA side. So I think that that's a good complement. I think that's the way it should stay. The Eighth Circuit Court found the same way after the Missouri legislature passed the prompt pay bill, and I hope you will vote against this bill. I'll hold for questions, Mr. Chairman.
Okay, question from Representative Seltzer.
Thank you, Mr. Chairman. What was the impact back in '99 when a similar framework was applied to the fully insured market? I understand insurance companies are, there's a Georgia company, then there's a Florida company, and that's they kind of go into that moniker, but there's also a lot of commonality to multi-state organizations that provide services. So it's certainly an interest to have as much uniformity across the states. I think that's really the crux of your issue.
Correct.
Could you speak to what happened in '99, how disruptive that was? Because that might point us to how disruptive this could be if we do the same thing to the third-party administrator.
I think the intent of the '99 legislature, obviously wasn't here, was to say right now there's not there's not an appropriate level of oversight of that fully insured marketplace. They put it there. Luckily, since 1974, there has been oversight of the ERISA plans and the third-party administrators that administer those claims. So I think that was the intention of the '99 bill, and I think the intention of this bill, 2009, is to give state oversight where federal oversight already exists.
What kind of oversight does ERISA give specifically with respect to prompt pay provisions?
What ERISA does is it tees it up for the U.S. Department of Labor to set rules and regs over ERISA plans and the third-party administrator administering those ERISA claims. What it says is 30 days to make a claim, to make a determination on a claim, and then if after 30 days, if it's a paper claim like we've heard here that a lot of providers submit paper claims, it gives us, if you notify the doc within 30 days, you have another 15 days to make a determination on that claim.
So it's 30 days to make a determination, and then how many days to pay?
45.
45. So the frame, is it a 75-day framework from delivery of care to
The
pay?
way I read it is 45 days total. So an additional 15 days, so a 45-day maximum. So they're already guaranteed. In most cases, especially on a clean claim, they're getting paid in 30 days, and usually a lot faster than that. We use the exact, all insurance companies I know that I represent use the exact same system for the fully insured and the self-funded market.
Okay, so if you're using the same system for the fully insured in the same market, is there a problem with compliance in Georgia?
Like I said, Department of Insurance has been keeping records since 1999. Exact same system now, so you got to figure whatever it is for Georgia is what it is on the ERISA claims, 95 to 97% of the time.
So you'd be complying with this law right now, even if we weren't to pass it into law, is what you're saying?
Correct.
So passing into law is not going to really have a major impact on your company or the ones you represent.
I would disagree. I think the reason why the compromise there is because the 95% is already there. Some insurers are going to say exactly what you just said. Okay, we already comply. However, the coalition that I represent of Aetna, Cigna, and United feel we don't want to see what happened in Georgia, what happened in Missouri. That we put state oversight over those ERISA claims, whether it's through the third parties or whether it's directly on the Cokes and the Home Depots. Then there's going to be a lawsuit. Then it's going to go to federal court.
But if, in fact, we think we've got a constitutional law,
sure.
I mean, it may or may not be good policy. That's sort of the second question.
Yes,
not
sir.
that it's less important. But if we think what we've crafted is constitutional, and that the Missouri law ran afoul of the Constitution, perhaps for drafting and what their framework was, but if this committee believes it's a constitutional law that's not going to have that protracted fight, and that at the end of the day is going to come out sort of upholding what we do here,
yes, sir.
That the companies you represent are already between 95 and 100% compliant, and from the standpoint of having a sort of a major negative effect on your clients, that's not going to be the case because they're substantially compliant today.
They are. I think what Representative Henson was speaking to, that patchwork quilt, that person that's sitting there, the third-party administrator basically does the paperwork between the provider, the medical community, and the Coke and the Home Depot, kind of sorting through there. Sure, are we already 95 to 97% compliant? Yes, we are. But also they've got to realize that what is Georgia law is different than what Missouri law was, what Alabama, and that's where you get into that patchwork.
But you're working in a number of states right now with your companies, aren't you?
Correct.
So even though they're operating in multiple states, meeting a 30 and 15-day framework is doable for you today. So complying with whatever we do in Georgia in a 30 and 15 framework is doable. And I wouldn't contemplate any other state would be more rigorous than that.
Georgia is the most stringent law on the fully insured market. And then, of course, at the federal level, at the U.S. Department of Labor sets, continue to break out those two segments of the business, the ERISA claims, the self-funded, and the fully insured. Fully insured, state regulation, self-funded, federal regulation.
Thank you, Mr. Chairman.
Next is Representative Carter.
Uh-oh, he's going to come get me.
No. I just want to ask you. I'm having trouble understanding what was this referred to? What kind of scheme? It was
Ponzi?
No. No, I mean, no. What I'm having trouble with is this idea that because ERISA is federally implemented, that no state should do anything, and we should all follow what ERISA says. I mean, is it not true that you just said that you're in more than one state?
Correct.
You
Yes,
administer
sir.
plans, and there are differences all throughout your plans, throughout all states. You don't reimburse the same thing for the same procedure in one state that you do in another state. So we're supposed to accept the argument that it's going to make it more difficult for you to administer the claims because the payment dates are different?
What I would say is exactly that, Representative Carter. Because they are different, wouldn't this be the appropriate venue instead of Georgia, Alabama, Missouri, wherever it be? Shouldn't it be in the halls of Congress? Would be my reply to that.
I don't know. We could get into an argument about 10th Amendment or something. I mean, but it would appear to me that this is nothing more than business as usual for companies or for third-party administrators that are in different states throughout the country.
I would disagree just because as we go through, like we said, Georgia's the most stringent. The Missouri law that passed said 40 to 45 days. Tennessee's 30, Alabama's 60. I mean, you just start getting into a web of regulation, whereas now for ERISA, I agree with you at the state level. On the fully insured market, those are businesses that do business within the confines of one state most likely. That's an appropriate place for state regulation. Whereas not is where regulation has existed for 35 years with a uniform federal policy under the U.S. Department of Labor. We would like to see that continue. Thank you, Mr. Chairman.
I have a couple of questions for you.
Yes, sir.
Do you have a copy of the bill with you?
I think I'm working off the old. Thank you, Mr. Chairman. Yes, sir.
On page 3,
Yes, sir.
line 79, 80, 81, this is the section that deals with, as I explained earlier, this is not in this case, you're not talking about insurance companies taking money out of their, make things simple, their checking account and
That's right.
And paying claims. This is we're dealing with them administering an insurance plan for a self-insured company. This is supposed to be the section that was put in order to give some protection to the third-party administrator. But one thing that kind of bothers me a little bit about this section is it seems a little bit vague as far as what you can and cannot, or what kind of evidence has to be put out there. It says unless the administrator provides sufficient evidence that the self-insured health plan failed to properly fund the plan to allow the administrator to pay any outside claim. I mean, what would be sufficient evidence? I mean,
that's a great question, Mr. Chairman. I certainly see where you're coming from on the vagaries of that. I would ask those that were here when the compromise was struck, or members of the third party administrators that do support this compromise versus those that don't. I couldn't speak to what they were envisioning sufficient evidence to be. I think what that's trying to say is kind of like you go to the bank account, and the Home Depot hasn't put it in there yet, so that gives you an out on having to pay that claim.
all right, well, I guess the thing that would bother me is the fact that I do know that different companies can put money in at different times, and if they don't have it in at one point, but yet they put it in later, you could actually knock yourself out of that 15 or 30-day mark just by not being in there, and then you've got a whole other deal that you're going to try to figure out, okay, did they actually have the money in there or did they not have it in there? And we're going to do that for every time that happens? That seems...
Certainly see where you're coming from, Mr. Chairman.
like that could be rather confusing. Now, you talked about the court cases and whatnot. Do you know, are there any current court cases right now that are ongoing that's dealing with this type of matter?
There was one in Texas, but I think it was been resolved.
I can answer those questions. Actually, right now, is there a current court case? No, not that I'm aware of. What you had and what Graham is referencing is that the case that you have before you, the Schottinger case, basically that, in its simplest terms, gave an insured person, an employee, a right under ERISA and a right under state law. That's why that one failed. and I can sit here and go through the entire cases. Baylor was a Texas case, that was okay. Ohio had a case, that was okay. Pennsylvania had a case, that was okay. If you would take our current prompt pay statute, okay, and if there was a challenge on our current prompt pay statute as written, it would go along the lines of, probably in my opinion, the Missouri case. But what this statute does, and the way this one is written, is to apply only to providers. So there is no duplicative benefit under ERISA and state law for the portion of the statute that applies to the providers, if that helps.
Mr. Chairman, I don't mean to beat a dead horse, but as part of the Missouri finding, it's actually pretty interesting on page 5, and I can pass this around. It actually, the 8th Circuit Court of Appeals says, plaintiffs rely on the decision in the Baylor case, and then, I'm quoting, we are not persuaded. So certainly, I think you can tell that this is lawyers on both sides, heavily contested. There will be legal cases. So I'll leave you with that, Mr. Chairman.
That's one of the things that concerns me right now with the budget and the condition that it's in right now. I'm assuming that if this were to pass and were signed by the governor, we would end up in a lawsuit.
Well, we have an attorney general.
Yeah, that we fund.
Mr. Chairman, can I respond to that?
Not right now, because Michelle Henson's in front of you. Representative Henson.
Thank you. I have
Yes,
a
ma'am.
question to ask you. The state health benefit plan is the largest self-insurer in the state of Georgia. Is that correct?
Yes, ma'am.
Okay. And then we have Medicaid, and which picks up, what, 400? I forgot how many thousands of lives. Is it close to 300,000 or 400,000 lives? I know. But now, how many other plans or what percent of self-insurers does the state health benefit plan comprise in Georgia? Is it of the lives that are insured in Georgia under self-insured, what percent of them are under the state health benefit plan?
That's a good question. I don't think anybody from DCH is here that could answer that question, ma'am.
I think what I'm really questioning is how much does this really affect in the long run in terms of the numbers of administrators, the numbers of people that we'd be covering, and all?
Yes, ma'am. That's a good question. Like I said, of the folks that I represent, Aetna, Cigna, and United, which represent many, many Georgians, and certainly those that are, I think United does the books for AT&T, and I don't want to speak out of school, Home Depot, or is it FedEx? I don't know. Anyway, many, many, many Georgians that are employed, that their employers have said, we will assume the risk and we will offer this benefit to our employees' health care. So that's who we're here defending today.
Thank you.
Thank you, ma'am. Thank you, Mr. Chairman.
Mr. Chairman, my name is Faye Brown. I represent the Georgia Academy of Family Physicians, and I'll just take a minute of the committee's time. I just want you to know that the Georgia Academy fully supports this bill, prompt pay, and the Medical Association of Georgia stand on it. Thank you.
Good afternoon, Mr. Chairman and members of the committee. I'll be brief. I'm Lauren Wiltz with the Georgia Chamber of Commerce, and I'm here today to let you know of our opposition of Senate Bill 62. With all due respect to Senator Hudgens for bringing the bill, the Georgia Chamber has a longstanding position of opposing any mandate on employer-sponsored health plans. We also oppose any attempt to erode the provisions of ERISA. Senate Bill 62 may be worded to the third-party administrators, but in doing so, it would directly affect the Georgia employers and the millions of Georgians who depend on them for health care. For these reasons, we ask for you to oppose Senate Bill 62.
Do you believe that if this were to pass, that this could directly affect the cost of health care when it comes to folks who are self-insured, whatever the fees that they're currently paying?
Yeah.
Is that why you're opposing it?
Well, we really are opposing it mainly because of we oppose any mandate on the insurance plans that our employers provide to their employees. but I can't answer all the technical insurance questions.
If I can figure out who number 23 is, I have a question. Who's 23?
Yes, sir.
Representative Hurd.
I'm trying to understand the opposing it because you call this a mandate. I don't quite understand that, ma'am, all due respect. All this is asking third-party insurers to do is to follow up under the same guidelines that all the other insurance companies that administer or insurance programs, health insurance programs in the state. And that's really all we're asking. I think that's all the author's asking. So I don't know why that's not really.
Well, we have a committee at the Georgia Chamber made up of business leaders and that are all across the state, and they've reviewed this bill and similar issues like this, and they do feel like it's a mandate that the state would be imposing on them.
To pay prompt.
Yes, sir.
Okay.
Thank you.
Wait a minute. Got one more. Representative Carter.
It's friendly, really.
Okay.
And that's okay, Mr. Thompson. You can come up because it really does kind of. I guess I'm just not getting it. I mean, you tell me that y'all are already adhering to this already, pretty much, and yet you don't want it codified. You don't want to put it, and I just don't get it. And the argument that you use that you want it to be uniform throughout the nation, I just can't buy that. I don't go with that. And then to say that we're afraid we're going to get into a lawsuit, well, my goodness, if we're going to dictate all our decisions on the fear of a lawsuit, well, then, sure. I don't know.
I think that because we've acted for 35 years under ERISA, past 1974, under that uniform regulation of ERISA plans, 35 years we've done that. Now in 2009, without any data shown, anything but anecdotal data shown by the Medical Association, now the state feels compelled to add redundant regulation of the third-party administrators of ERISA claims. Where's the problem? This seems like a solution looking for a problem. I've shown the data that under our payment system, which are uniform, whether it's ERISA or fully funded, 95 to 97% compliant, and that's since 99. If there are problems out there that go beyond the anecdotal, one time I didn't get paid over here, then please present that data. Certainly we'll respond to it, but again, it looks like a solution looking for a problem.
And again, with all due respect, I'm just not getting it.
Thank you, Representative.
Representative Seltzer.
Mr. Chairman, I'll wait. I'll ask a question then.
Thank you.
Mr. Chairman, members of the committee, I'll be very brief. My name is Temple Sellers, and I represent the Georgia Hospital Association. We come to you in support of this legislation. To us, this is really, it is not a complicated issue. It's a pretty simple issue. We have tens of thousands of employees, and in order to pay them on time, we really need to be paid on time. And we see this as just a very simple, fair provision. I think the question that was asked with respect to patchwork has really been answered by the opponents of the bill. They have the thing that I think we need to understand is that these TPAs, it's not like there are TPAs for self-funded plans, and then there are TPAs in Georgia for the other non-self-funded plans. These TPAs do business for both in this state. They already program their system to pay for 15 days for that pool of their clients that are not self-funded plans. So it isn't as if this is forcing them to create a patchwork. That exists by simply the nature of them doing business in this state and having certain requirements that apply to certain of their clients. And so we would just ask your support for this legislation.
You have a question, Representative Seltzer?
Mr. Chairman, this is the question I was considering asking before. So am I hearing you say that that in fact, and this is what I thought I was hearing as I was hearing the earlier testimony, was the compliance exists today between 97 and 99% in terms of payment terms?
Yeah, well, we would dispute that. I mean, that the issue of whether they're actually doing it in a timely way, I think, If in fact they were compliant to that degree, we wouldn't have this bill. I mean, we need it because there's a lack of compliance. But the issue of whether or not it's difficult for them to comply or it's going to create this patchwork approach, I think is incorrect. It's very simple for them to create a system that pays everybody the same way, whether they're self-funded or they're not self-funded.
Well, to the point, though, I mean, I heard the opponents say that they're already compliant with this between 97 and 99% of the time. So the issue of can you get there from here shouldn't be hard to achieve. I guess what I've heard is really the opposition amounts to something that's philosophical.
I think that's absolutely accurate.
Is this, has a group of people gotten together and classified this as a mandate? And are you philosophically aligned with allowing the federal government and the federal government only to address in a regulatory scheme these third-party managed plans, or should the state be in the business of regulating it at all? The objections that I heard really at their crux, given what sounds to me like some compliance, seem to be more philosophical in nature. Would you agree with that?
I do agree with that. Yes, sir.
Well, I have a question. I guess the problem, I see where some people have where they think that this is, kind of a good idea. In the 15 and 30 days, it sounds like a really great thing. However, I personally philosophically have a problem with it on this basis. If I know you up here and you say you support this bill because obviously you benefit from this bill. However, if this bill up here said that all maybe nonprofit hospitals or all doctors' offices had to pay all their vendors within 15 to 30 days, would you come up here and say you supported that bill?
I can't answer that because
we have.
No, I really can't because I don't make the decisions about our positions on legislation. I imagine we would have to go through the same process we do on every bill to see, what kind of feedback we got from our membership.
Okay, I'll see more questions. Okay, if anyone, you can be seated.
Okay, thank you.
Do everyone else?
Thank you, Mr. Chairman. I'm Nelda Green with the Georgia Dental Association. Just briefly wanted to affirm that the Georgia Dental Association does support this bill, as dentists are small business owners as well, and we would appreciate your support in this endeavor. Thank you.
Thank you, Mr. Chairman. My name is Alan Hayes. I work for United Healthcare as a contract lobbyist. I was the former deputy insurance commissioner, and I'm a licensed insurance counselor. And I'd like to say to your philosophical question, Representative, I think the fact that these plans are already regulated in a pretty big way by the federal government. To say that's a philosophical argument is like saying that is the same philosophical argument I would make that says more government regulation, increased costs. And I think it's something you'd probably agree with. This is, make no mistake about it, this is more government regulation. It's going to increase cost. I don't know to what extent, but I can assure you, and to the extent that this may be a good idea because we're already complying, again, philosophically speaking, from a conservative governance standpoint, just because people do something as a way of business does not mean it needs to be a law. We may want to change. Someday somebody might invent the 5-day prompt pay system, but there'll be no incentive to do so because the government only says we have to pay in 15 days. Just from a philosophical standpoint. I'm very good friends with Chairman Hudgens, and I appreciate him bringing this bill. But when he talks about the National Association is trying to fight against a national insurance czar, it's exactly because of this. This is the kind of thing that the feds say, or their companies go to the federal government and say, we need relief from this. That doing business in 50 different states with 50 different sets of laws is not working for us. It's a very big burden on our companies. We need a federal regulator that will regulate it federally. So it's almost the opposite of what he was saying when we talk about it. As a regulator myself, for 5 years, I can assure you that the companies that the company I represent, United Healthcare, and the companies that are represented by Graham, are compliant. I can't stress that enough, that the only data that exists in this state is the data collected by the insurance commissioner in this state on fully insured products. And that data says that companies are compliant between 95 and 97% of the time. I will warn you this. I mean, it's clear. I don't support the bill. I hope you vote against it. But there will be lawsuits. I don't know of a successful case that this law has been upheld. The most recent court case that you have in front of you, prompt pay statutes were struck down on former ERISA. So what you're going to be left with, to the point that Representative Reese made, and Representative Henson for that matter, is you're going to have the ERISA stuff will be struck down. You won't be regulating the TPAs or the ERISA plans, but you'll have a very much weaker prompt payment law. A law that has been negotiated by some health plans and MAG to weaken the current statute. That's what you'll be left with. I'm not sure that you necessarily want to go there. Again, we may benefit, as an insurance company, we may benefit from those lower prompt payment laws, but that's probably not something you had intended to do when you look at this bill. Again, I strongly urge you to vote against it. It may be a philosophical disagreement, but it's a real one, and one that I honestly believe in, that more government regulation, increased cost, it's harder for people to do business, and companies look to do business in states that are friendly when it comes to regulation and taxes. I mean, I think that's something that we probably share an agreement on. I'll answer any questions. Anyone else? Sir, I think you had been.
Yes, sir. Thank you for the opportunity to speak in support of this. I'm a doctor in this state, and I get a little lost in all the legal discussions and in some of the philosophical discussions. I try to avoid legal discussions. What I've heard since I've been in here is the problems with regulation and cost, and certainly with the regulations I've seen develop over my career about trying to get paid from insurers that seem to delay payments significantly. As I talk with my business manager, I have concerns, and we pass state laws that are to address that. It's of concern to me now that insurers are third-party administrators, and so they aren't bound by the same regulations. And I hear this from my colleagues in the House of Delegates. I think this is a concern to doctors, and we can try to bring the evidence of that fact. But I would urge you to support this from the standpoint of the effect it has on doctors. If there is a mandate, it was a mandate passed by this group in our state laws, and I think we ought to be bound by them in this state. And I would hope the federal government would follow your wisdom in adopting those federally. Thank you.
Thank you, Chairman Butler and members of the committee. I'm Mary Squires. I'm the Executive Director of the Georgia Society of Professional Benefit Administrators. We represent third-party administrators and employers who self-fund their health care plans. We do support this legislation as written, and we are part of the compromise with Chairman Hudgens. We worked with him last year when he had this under different bill number, and we absolutely support prompt pay. What we see that happens in this state is that right now these figures, though somewhat devastating because of the employment situation that we're in, with so few people, with people losing their jobs right and left, now what used to be kind of a 60-40 spread, 40% of people who are employed were under fully insured health care plans, 60% were under third-party administrators. It's now, according to the Self-Insurance Institute of America's information from a couple weeks ago, it's now at 80% under third-party administrators. And a third-party administration is, we're not bound by prompt pay laws. We are, and it may seem that, we shouldn't be supporting this legislation, but we do see that we're in the communities. We're local. We know our doctors, we know our hospitals, and the doctors, some groups and some hospitals are self-funded by us as well. This isn't just about Home Depot and Coca-Cola. They're under what's called administrative services only. Administrative services only organizations are part of fully funded insured companies. They have their own TPA entity. We're the little guys that do TPA work, and we want to play ball with our providers throughout the state. I think that this Chairman Hudgens is doing a service to the state by having this prompt pay bill. 15 days electronically is fine. We asked for 30 for paper because paper is a fact of life. Paper is not just a fact of life from the provider standpoint, the little providers that can't do electronic, but we get it in, we code it, we make it electronic, we run it through algorithms that check for fraud and abuse, for CPT code duplication and other things, and we take care of them. So 30 days is just so that we can make sure that we get everything done. But we do support this legislation, and I'd be happy to answer any TPA questions you might have. Thank you, Mr. Chairman.
Mr. Chairman, in the interest of time, I don't know of anybody else that's going to speak, but I'd like to speak to 3 different areas. And Representative Hurd and I have for many years represented Athens-Clarke County. And when the state made their transition over into these Medicare districts, I think that Representative Hurd was contacted just like I was, that Athens-Clarke County was, the Athens Regional Hospital and St. Mary's were both owed millions of dollars in claims that were not being paid. And they contacted me and said, can you get these people to pay us because we can't even make payroll. We're going to have to go borrow money to make payroll. And so we were able to get some money from some of these Medicare providers for this, but if we had this law in place, that would not have happened. The other thing that I would like to address is this idea that this is a mandate. You know, this has been my bill all along. I've never heard the chamber. They've never come to any Senate Insurance Committee meeting. They've never approached me about this being a mandate. I just can't see how in the world they could classify this a mandate. And the third thing that I would like to address is Mr. Thompson, who is a close friend of mine and have been friends for years, but to come up here and I guess scold us for the compromise on the interest rate, on the number of days, and the percentage of compliance, when the compromise was made for their industry, and then to fuss at us for making the compromises is a little disingenuous. I just can't see that. So I just think you've heard all you want to hear about Senate Bill 62, and I think Representative Manning is right. You know, why bring us an insurance bill? And I wish we hadn't. I wish it had been in the House Insurance Committee where there would be more knowledge beginning. As I said to begin with, Representative Hurd's the only one that, to my knowledge, that really is up to speed on insurance issues because he is on the House Insurance Committee. But I urge you to pass that, and that would be my close. Thank you, sir.
I would just like to say for those of you who are not on the insurance committee, we've heard this bill and heard it and testimony after testimony after testimony, and it did pass the House Insurance Committee with a due pass recommendation, and I'll just leave it at that. Thank you.
Thank you, Mr. Chairman. Makes me want to readdress an issue I mentioned years ago about making people that testify at committee meetings take an oath and liable for punishment if they lie. Not saying anybody did. I got friends on both sides of this. I don't know if you're open to a motion, but I don't feel qualified enough to vote on this bill. I'll just be honest with you with that. And so if a motion is made for a vote, I'm going to vote no. And I would suggest this get asked by the Speaker to assign this to the Insurance Committee where it needs to be.
Hey, Mr. Chairman, I came into this today, Mr. Chairman, somewhat on the fence. But just listening to this play out, I'd looked into this issue and done quite a bit of thinking about it. It seems you've got both the practical and the philosophical. Philosophically, I asked the question, is the regulation of insurance a limited specified power of the federal government in our Constitution? I'm not persuaded of that. I mean, I understand that there are certain things that it's appropriate for the federal government to do, and I think those things were outlined by our framers. I don't find this to be one. So philosophically, I'm not persuaded. But again, in the realm of the practical and the getting the work done for the people of Georgia, I was certainly open to hearing and listening to the mischief this was going to cause providers who are trying to keep low-cost health care available to our citizens. And I asked some hard questions of the Medical Association, asked some hard questions of those that are opposed to the bill, and I find, although there's certainly some contentions and some anecdotal contentions that prompt payment's not happening, which may exist, I'm not persuaded that the players that are engaged in this game aren't able to do this pretty easily today anyway, and are in fact not doing it already. I sense that they are, and that this would be something that could be taken very easily in stride with those providers that, and I understand their concern with having, facing different state regulations, but it certainly seems we're consistent with what they're already doing, whether they're providing the same service in a fully insured environment or a third-party managed-only environment. It seems to be the same players that are using the same systems to manage that. So both the philosophical side and the side in practice seems to support a due pass, although, Mr. Chairman, I won't make that motion this time.
Thank you, Mr. Chairman. I am not on the insurance committee, but I deal with insurance all day long. And if anyone's got as much experience with it as I do, then I applaud you. But I find it appalling that someone representing an insurance company would come up here and tell us that we're trying to make it more difficult. Have any of you filled out an insurance claim lately? Now, how can you get any more difficult than that? And for us to try to do something as simple as this, I'm just taken aback by it. Thank you, Mr. Chairman.
There we go. I'm not used to using this little touch screen. I want to hold this bill for a couple of days. I have some questions about the rest of stuff that I need some more information for myself personally before I feel comfortable with this. I think a good point was made in the fact that if we pass this bill and it does go litigation, then and the ERISA stuff is taken out, then we're left with a weaker insurance law. That does give me some trepidation.
If we take the ERISA stuff out, then we don't need it. I mean, we don't need the bill.
Well, that's my point.
And so I guess what I hear the chairman saying is that he's going to kill the bill for this session.
No, I didn't say that.
Well, you can hold it a couple of days. There's no way that we can have a full committee meeting, go through rules, and get it on the floor.
Yeah, it still might be possible.
Yeah. We'll have to disagree on that.
All right. With that, I call this meeting adjourned.